My name's James Williams. I'm an attorney at Tengen Law based in Richmond, Virginia. And I am working in the space of intellectual property, business formation in Virginia, and then intellectual property like copyright and trademark. One other central aspect of my firm and my business is immigration. And so if you end up wanting to chat about the legal perspectives about any of those things, then this is a very casual and just informal space to have what I refer to as office hours. So you can come in, you can chat about legal stuff, news, lawsuits that have been filed, all those things, bills. I try to keep most of that limited to the gaming industry, but yeah, if something comes up and the community's really passionate about it, then, we can talk about it. Might put some boundaries up around that if the time comes, and I'll just get into that there. But anyway, like I said, I'm a lawyer here. I went to MagFest and I joined some of my friends at Premac Rogers Downs, and we did an intellectual property panel. So there were a couple of them. My mentor, Noah Downs, was on 12 panels over the full 4-day MacFest event. And so he did a lot of law panels. He did a lot of non-legal focused panels as well about podcasting, about TTRPGs, and other things. Of course, he could talk about the legal side of all of that, but we had a pretty good time just going into the basics of intellectual property like copyright and trademark, something I've done here. And so if you're ever curious about any of those videos, then I've got a link to our YouTube page specifically for this channel right here, where you can go through and catch all the VODs. We're also pulling clips and putting those shorts on there as well. Let me see how our page is looking right now. How are my shorts doing? Oh. They're doing all right. About what I'd expect. Okay, cool. So yeah, just check it out. I'll go ahead and plug in some of my other stuff as well. If you want to get to follow me and check in with me offline, we've also got a Discord as well. I can drop that link if anyone wants to ask for it. Okay, so big things. I mean, when the lawyers get together, it's a lot of just spitballing and complaining about things. And sometimes they turn into really productive conversations, and other times it's just like, work, you know what I'm saying? That kind of stuff. But I've been trying really hard to basically come up with content creation plans and educational seminars or other things related to that. But I'd like to be in a position where I can get into a little bit more advocacy. And so that reminds me, I'm going to do something else. Pardon the neurodivergence here. Let me see if I can follow. What I was starting to get into is just some of the things that we talked about. We were expecting quite a bit of questions, just many questions about Steamboat Willie, Mickey Mouse, maybe some stuff about AI and tech, and then a bunch of fair use type questions of, well, I make fan content and I sell downstairs in the marketplace, but this mean company, Nintendo, keeps sending me these letters we kept expecting a lot of legal advice type questions like that. But honestly, we didn't get any questions that were quite so hard for us to manage. I mean, everything was kind of just like, generative AI, can you explain some of the potential legal consequences? And like, that's something that I've been talking about here, and I've looked into a little bit more. There are definitely some updates. There's a lot going on in terms of litigation, in terms of policy adoption as well. And so policies, we're talking about like terms of service related policies. We're talking about, let's see, what other things? I don't know, just company-wide policies on whether AI or generative AI specifically can be used. But yeah, I mean, very much still keeping an eye on the different types of tools and trying to figure out how they can source the underlying content that they use to generate, you know, the end result content. All right, so I'm just going to go through some of the bullet points and things that I remembered in my stream of consciousness time. And so whenever we talked about fair use and whether companies sue, I mean, one of the questions that came up was basically like, how does it work here? But like, how does it work that there is an entire Smash database online, but Nintendo generally is notorious about cease and desist letters, DMCA notices, all that stuff. And any question like that, it really just came down to, well, unless we're in the room with the people who make the decisions, we don't really know. But practically speaking, it's going to come down to two things. One, the willingness and ability to enforce the IP that's there. And willingness also includes, or the ability part also includes like money and time. And then the other aspect is really just, is there some social or cultural value that they're trying to defend? And so like with Nintendo, you know, the first part, it really just comes down to, is it going to be worth the money? Is it going to be worth the resources to have their team, their legal team, go out, find everybody, and take them all down? For most content, if you aren't super successful and making a lot of money as a fan creator, then you're probably not going to be worth their time. They're not going to get a lot of return on the effort that goes into it. So it's just a purely business and financial type decision there. And so leading into the second point, it always just comes down to, hey, if Nintendo wants to hold itself out as a family-based company, then if you're making adult content or content that involves drugs, alcohol, controlled substances, and the like, then that may be something that goes against the value of the company. And regardless of whether it's copyright infringement that they're seeking or a cease and desist, or like a cease and desist tied to trademark or some other legal consideration, that's generally what's going to motivate a company to get involved. Even if they don't necessarily have a strong case, you know, those are going to be the times that they're going to want to do it for sure. So that was kind of the answer we gave at the time of the panel. It's just, hey, it's a business decision. And, Artist Alley, the marketplace in most of these conventions, just not going to be worth their while. Unless they happen to have legal counsel there and they're like, please just take this down, here you go. But that'd be expensive to send people to like every single convention. So, yeah. But, those big tournaments, things that get really viral, there's a good chance that somebody's going to see it and they're going to say, hey, boss, we got to deal with this. So just keep that in mind. But, we always get the question of how can we deal with fan content? Like, how can you make it safe? The short answer is get a license, get permission from the company that you're using their characters and their content to make your own derivatives. Because that's, generally speaking, how copyright law is going to deal with or view your fan creations. It's all generally going to be a derivative work. There's an asterisk there. It's going to come down to your individual uses and all of that. But a lot of people just recast the same characters and they just, make stickers or other merchandise. And that's all just going to be derivative works for the most part. So that gets me into another topic that it's a problem I'm trying to look into. And it kind of just hit me in a way that is probably really obvious. But I was trying to think about, maybe we can look at something like music and how they've got a mechanical license. And it's basically like an automatic royalty setup. And I was just trying to think about if there's a way for us to kind of come up with mechanical licenses for fan-based content and also apply that into, any of the various services or platforms, whether it's Twitch, whether it's YouTube, Etsy, any of these big marketplaces of content. And the more that I thought about it, I'm like, well, okay, here's the deal. If fan content is going to be intellectual property and derivative works, then there's not really a way to bolster the rights of fan-based content without also limiting what is a derivative work. Maybe that's what we're looking for here, but that would need to be super narrowly tailored for it to be practical. And so what do I mean by that? Well, derivative works came up in a variety of contexts because, let's say, if copyright law was founded with the basic idea of the printing press and writings, then, derivative works were translations, which were originally seen as a fair use, but now they're not. And so that all just comes down to, hey, there's a market in that translation. And so big corporations or big rights holders are never going to be in a position where they're going to want to limit those derivative rights that they have. So that's the tricky spot about trying to come up with some fan content based license that is going to go across the board. And just to be clear, the licensing that I'm talking about is something to enable people to basically make Etsy stores or other things. Like if you're going to make a derivative work or something and it's going to be for personal private use, like you're probably going to be fine anyway. But how would we legitimize Artist Alley, I guess, is a question that I'm trying to figure out. Yeah, that's kind of what I'm getting at.